Hey folks, I want to talk to you about the importance of avoiding a cookie cutter approach to EB1a. In thinking about your EB1a scenario, if you have started the process with, for example, a company attorney or somebody else out there, and you're being given a template or a checklist, you may want to re-examine the legal strategy that is required to actually get your case over the finish line. An EB1a case is one that is quite subjective and needs a uniquely tailored approach to make sure that it is presented in the very best way. When we look at the EB1a, the most important thing is the final merits determination. And the final merits determination is about demonstrating that you're going to be at the highest percentage of your field. So what that takes is a lot of in-depth analysis regarding what your field is, how to describe your field, and present that field to the adjudicator in a persuasive manner. At the same time, when you're thinking about the regulatory criteria, that is the minimum of 3 of 10 criteria needed in order to meet the entry-level requirement of the EB1a, you don't necessarily have a situation where every regulatory criteria is weighed equally. Rather, some criteria are more important than others. For example, if one is an artist, then the idea that their artwork is presented at an exhibition or showcase is going to be a lot more important than whether or not they perform a critical role. Likewise, if one is a technology-related contributor, clearly an original contribution of major significance to his or her field is going to be the most important regulatory criteria for that particular case. So, for example, if you have 3 criteria and they are related to authorship of articles, judging others' work, and maybe membership in a professional organization, but your actual field is engineering, then you're not going to be approved. You're going to get probably an NOID and followed by a denial, because the regulatory criteria that actually matter, that have weight in your case, are not going to be those 3 that you have presented. So be very careful about your strategy. Do not take a cookie cutter approach. Do not take a template-based filing that is very probably intended for somebody who's not in your field, and don't just think that it's a matter of checking off a list. It's not checking off a list. You need a uniquely tailored approach with a proper legal strategy, and that is why it's not just about checking boxes. So I hope this is helpful for you and look forward to hearing your feedback.